Your Free to Go is sponsored by Milburn Men's Clothing, where top athletes shop for sharp, tailored style. And whether Marc and I are in the studio or the courtroom, Milburn dresses us for success. Mention YFTG and get 10% off at Milburn Men's Clothing, which has been providing the finest in men's clothing and suits since 1946. Call 651-645-2922 or visit www.milburn.com. Welcome back, everybody, to your favorite podcast, You're Free to Go. As you know, we're the podcast of real criminal defense lawyers talking about our real cases. Something you never hear when you listen to these true crime podcasts. We're the actual lawyers in the trenches. Well, today we're going to deviate a little bit. We're going to talk about a couple cases that are in the news, some high-profile media cases. Marc and I are going to talk a little bit about the P. Diddy case. At first, we're going to actually start talking about the 4 Idaho University students that were murdered and the accused who just admitted guilt and was sentenced recently, named Brian Kohlberger. That was a murder that occurred in November of 2022.
Yeah. And we're going to talk about those, but I have to give a cautionary warning here. I typically don't like to talk about, at least publicly, cases that I wasn't involved in, only because I've been involved in a lot of high-profile cases in the media, especially here in Florida, where, you get these other lawyers out there and they are quoted in the newspaper or on TV giving their opinions about things, and I listen to what they say, and I go, Jesus, they don't know shit about this case. So the bottom line is, I don't believe in calling in plays from the stands. If you're on the field, then you get to decide what's going on, but not if you're in the bleachers. So, but in this case, the difference in this situation, this episode. The difference is that, first of all, you were involved in the Diddy case.
That's right.
Like in the Epstein case, you were involved in the Epstein, you were his lawyer. And more importantly, we're not going to be talking about specific facts of the case as much as we're going to be talking about issues that are now coming up in general concerning the criminal justice system. Because as we've told our listeners before, we view this podcast as not only telling our stories, but giving an inside look into the real justice system, so people could truly understand what really goes on.
Yeah, it's more about the process.
The process.
And our understanding of the process and shedding light on that from our experience. But one thing you just touched on that comes up with me in a lot of conversations with people where they'll bring up a famous case that's in the news, and they'll say, Guy, why did they do this? Why did they that? What do you think the verdict's going to be? What do you think the sentence is going to be? My candid response is always, and it's really what you were just saying, is unless you sit in that courtroom the entire time and listen to every single piece of testimony and observe every piece of evidence that was admitted, you don't know. You can't opine on those things, because if you go to the bathroom and you miss 5 minutes of testimony, it could be 1 or 2 words during those 5 minutes that changes the whole dynamic of the case.
And even worse, if you decide if you give an opinion as a lawyer, as a criminal lawyer, on the case based on what you're just reading in the media or hearing on TV, in a reporter's comments, half the time these reporters don't even understand the nuances in the case.
Right.
And, the media doesn't necessarily report it accurately. So it's very prone to giving wrong information. It's like they say, junk in, junk out.
Right.
Right?
Well, yep. And fake news, which is a big term used nowadays. So, but let's talk about the process. But actually, before the process, I want to talk about this Idaho murder case of 4 students. Horrible, tragic story, just at home after an evening out as friends and sleeping, and someone breaks in their home and kills them. I saw an article in the New York Times just the other day, and when I saw the headline, I expected it was right after sentencing, right after the defendant pled guilty, was getting his life sentences. I believe 4 life sentences, I think is what he got in prison. So I expected to see an article about that hearing, that sentencing hearing, but I was really surprised. That wasn't the article at all. The article was about the true crime industry, the fanatics that are just obsessed, the massive number of people that are obsessed with true crime, that are addicted to true crime podcasts, that are addicted to shows like Dateline, and the theme of the article was how that new industry impacted this particular criminal case.
Well, how did it do that?
In so many ways that you can't even imagine. As I read this article, I was shocked. And this is a new phenomenon that we as criminal defense lawyers and prosecutors and judges are going to have to react to. So one example is, so there were thousands of people that watch these true crime, whether it's a podcast or a Dateline show. They started following this case really, really closely. And at the beginning, when the murders occurred, it was a while before they figured out who committed the murders. All that time during the investigation, thousands of people were calling the local police department in Moscow, Idaho, with theories, because all these guys are now experts. They've been watching so many Datelines or listening to so many true crime podcasts that they're now experts. And they were calling the police department saying things like, you got to check the waitress at the diner on the corner of such and such, or go to this store because I think that's where they purchased the knife that was used in the murder. And what happened was the police were running down thousands and thousands of empty leads.
What a waste of time.
And resources, right?
But again, they don't know if it's a real lead or not.
They have an obligation to run it down and prove that it's not a real lead. And it distracted them from doing the traditional, approach to good police investigation work, which at the end of the day, that's how they solved this crime. When I started reading this article and it said how they solved it, it was through traditional, investigative tactics. And all those calls they got from the people that are fanatical about true crime was really distracting, and it delayed getting to the person who committed these crimes, Mr. Kohlberger, as I mentioned at the beginning of the podcast. It also affected the judge. So, for example, there were times where a hearing was set and the prosecutor and defense agreed that they wanted to reset the hearing. But at that hearing, before announcing it to the judge that they wanted to reset it, hundreds of podcasters and reporters and people who like true crime, that genre, showed up to watch this hearing because they were following this case. And they were saying, Judge, don't continue it. We're all here. We've got our cameras. We need to be able to talk on our podcast tomorrow about the hearing. And the judge's like, no, I'm continuing the hearing. I'm not going to let social media and just, individuals impact how I handle a case. It's going to proceed in the normal course. So it had a lot of, put a lot of stress on the system. I also heard that even before the trial began, there were books that were inspired by this. There were YouTube videos. There were people posting. They started to read about the prosecutor's case, and people started posting how holes in the prosecutor's case. And so, as you know, eventually a jury is selected for a trial, and jurors are in the community. So they were actually witnesses to all of these publications that were having an influence. So it made
even though they're instructed by the judge.
Right.
Not to read anything about the case, but not to talk to anybody about the case.
But these were things before they showed up for jury selection. There were actually books written, posts, and all sorts of YouTube videos.
How do you pick a jury?
So,
if you got a problem with that.
That was the issue. It made it really, really hard for the state to pick, and the defense, to pick a jury of people who hadn't already been exposed to critical articles and so forth, and theories. So it got really bad. And this is a little bit different, but it was so highly publicized all over the world, but especially in Moscow, Idaho, that the judge had to do a change of venue. Mm-hmm. They moved the case to Boise, Idaho, which is the capital of the state. So it helped them find a little more, of an audience or a veneer of potential jurors that had less, exposure.
Well, right
to the
now,
case.
in this day and age, right now, it's almost impossible to find jurors who haven't heard something about a super high-profile case. I remember when the OJ case was going on, one of the local stations called me to ask my opinion on camera how to find a prospective juror on the case, given the fact that it was probably the most publicized criminal matter in America at the time. And I guess I ruined my chances of ever being on TV, but I gave them an answer that was, they considered very flippant, but I was being half serious. I said, I think you got to go to hospitals and find people who just woke up from comas.
Yeah.
And then they went like this, and that was the end of my
Right.
my interview and the
Yeah.
end of my career as a TV commentator. But I
Yeah.
thought that was pretty accurate.
Sure.
And that's the problem when you go to picture. But that'll be a whole nother
Yeah, it is.
thing. But
There was one final thing I want to say about
Yeah.
the influence that was really unbelievable. It got so bad in this case, this wave of just people following it and opining on it, that the judge actually issued a gag order, keep everything between the lawyers and the courtroom, and so it wouldn't get out there because there was so much speculation and criticism and analysis and theories being thrown around and so forth. And so the judge issued a gag order, so it couldn't be spoken about outside of the parties in the courtroom and so forth. And even after he issued the gag order, this is unbelievable to me, that this whole group of people following true crime online actually identified a key witness in the case that was supposed to be a secret and totally unknown. So this key witness's identity was disclosed by someone who was doing a podcast in this whole true crime genre. And so even though they tried to eliminate, the judge did everything he could to prevent the true crime followers from influencing the case, but it really did affect it. And you and I, as lawyers now going forward, we have to factor that in when we strategize how to handle our cases.
Sure. Absolutely. It's a whole new world. Well, the Idaho case also presents another very interesting issue that I've learned about, and that's victims' rights.
Yes.
And in that case, the prosecution decided not to go for the death penalty and to enter a plea bargain where he pled guilty. As a result, he got a deal to avoid the death penalty. And under Idaho law, I looked it up, the victims don't have the final say, obviously, but they are supposed to be consulted. They have a right to be informed of the prosecutor's decision. It's unclear whether a number of these victims' families were in fact, and I say victim, I mean victims' families, it's
Right.
a murder case, were in fact informed.
Yeah, there's a lot of conflicting information out there about that.
A lot of conflicting information about that. But it raises a very interesting issue because, passions run very, very deep in those situations. I can only imagine what it'd be like to lose a loved one through a violent act, and especially when you have multiple murders, in these cases involving mass murderers, where the evidence is clear, where the person's caught on the scene, these school shootings or whatever, and too many of them. God, it's horrible. But in those cases, you would think if there's a death penalty, that's the type of case it's reserved for.
Right.
When you viciously kill 4 people without any provocation, that seems the type of case that the death penalty is called for. And certainly, if I were the father or the brother or a member of the immediate family, I don't know how I would react. I would I would probably want to kill that person myself.
That's right. And I think a lot of people would agree with you on that.
Yeah.
I've handled cases in 22 states. I know you've handled cases in 30 plus states. Every state I've handled cases in, they do have this Victims' Bill of Rights.
Right.
So, and they're all very, very similar. And I tell clients, we represent defendants, people accused of a crime. When I tell them when there is a victim, I say, look, they have the victim has a lot of influence in the process. The state is required to keep them informed, and they're required to hear them out. They don't have to do what the victim asks, but they have to hear them out. And usually in the final hearing, the judge will actually say to the state, is the victim on board? Is the victim fully informed? A lot of times the judge from the bench will communicate directly with the victim if they're present in court.
Well, at sentencing, the victim can show up, but if it's already a fait accompli, there's already a plea deal. If the judge accepts the plea deal, saying everything you want as a family member at the sentencing is just a waste of time.
Right.
It's cathartic, but it doesn't affect the result.
Yeah, and from the research that we've done and our legal researchers and in our office has done, it looks like that may be the case here. But there were 4 individuals killed. So 8 parents at least. And you and I know victims come from different backgrounds. I've had victims that are very religious, and they say, "I don't judge anybody. That's up to God. I'm not taking a position." I've had people that, for whatever reason, they say, "I forgive. I don't ever want to hold, any type of anger or animosity in my heart. So I forgive. It's up to the judge and the state." And then you have the other extreme where you have victims who say, "I want them buried under the jail. I want them." And so the victims, do have a right. I don't know what their position was, the 4 families in this case, but there's a lot of, we use the term, conflicting testimony or information out there as to whether the prosecutor did fully inform these families or not, whether they were on board, I know I saw at least one said they wanted a trial. I know a couple things I saw was the victims were really upset. Apparently they destroyed the house that this occurred in. They demolished the house, and they were really upset about that. They thought they should have had the opportunity to go there and maybe mourn, and have some time before the house was demolished. I saw that the victims were upset that the plea deal that the prosecutor offered didn't require the defendant to tell them where the knife is. They wanted to know, where is the murder weapon, and they also wanted him to give a full confession. All he did was admit, "Yes, I murdered them." The victims wanted a full confession, and so it's disappointing that they didn't get that. Of course, as you were saying earlier, we don't know the whole story. This is not our case.
But it does raise a lot of different issues. First of all,
You're Free to Go is sponsored by Lang Realty, South Florida's premier residential real estate broker. Whether you're buying, selling, or renting a home or condo, Lang's experienced realtors are standing by ready to help you. Contact one of Lang's top realtors today at 561-703-2427.
the power resided solely with the prosecutor. Now, when you have a case that goes to trial and a defendant is convicted, let's say, of capital murder, then the decision, at least here in Florida, for example, goes to a jury whether or not to have the death penalty or not. You have what they call the penalty phase of the trial. And it's not left to the prosecutor. But when a plea deal is made, the victim, and in that penalty phase and ultimately in front of the judge, the victim's family can speak. But here, the decision was made by the prosecutor. Now, in all fairness, again, we don't know what was involved behind the scenes.
Correct.
Sometimes, and I've been involved in cases where prosecutors decide, look, they just don't have a guaranteed conviction. They're not completely convinced they're going to win the case on a murder one or the capital murder. They'll plead down because they want to see the guy go to jail. They don't want to run the risk. Of course, you have what they call lesser included offenses. Jury's given a choice between murder one, murder two, manslaughter, whatever. But I've seen cases where cases fall apart. Victims disappear. Something happens to the victim. Witnesses disappear.
Even in the strongest government case, they have the strongest case in the world. Defense has no chance. You tee it up for trial, and you're right. The key witness for the government doesn't show up. Things do happen.
Oh, things happen. In
it's
fact,
never a guarantee.
I always say to my clients, a case lives two lives: the life it lives before trial and the life it lives in the courtroom during trial. Could look completely different. I mean, people who say X, Y, and Z on paper, when they're put under the crucible of truth, which is cross-examination, all of a sudden they're no longer credible, or they say something different, or they give conflicting information, or witnesses come out of left field.
Right.
So prosecutors have the right and the duty to decide whether or not their case is strong enough to sustain a conviction on the main charge, and sometimes they enter pleas that are below the main charge in this case, or enter pleas that are for a lesser sentence than call for, in this case, life instead of death penalty. But I do believe that in any event, when they make those decisions, they owe it to the family or to the victim, if it's not a murder case, to explain that and explain themselves why.
That's
To
right.
give them some explanation. The family may not agree, or the victim, if it's a non-murder case, may not agree, but at least they have the duty to do that. And that's what I believe these victim rights statutes provide, and that seems to be what the Idaho statute
I
requires.
agree. There's also, from my experience, maybe you can fill in the blank here too, maybe because you've been in more states than I have. On the murder cases I've been involved in as a former prosecutor, there was always a committee that you would have to present in the state attorney's office or the DA's office that you would have to present the case to, and the committee would ultimately decide, are we going for the death penalty or not? That's by probably 8 different states that I've had murder cases, and that's how they did it. And I assume it's pretty consistent around the country.
Yeah, of course, many states don't have the death penalty. When
That's
I
true.
was a prosecutor in New York, we didn't have the death penalty.
Right.
But it's a very interesting case. Unfortunately, the die is cast. You've got families that are probably very upset and will have to live the rest of their lives with this incredible horror. But that's the way it goes. I mean, the justice system is not perfect.
It's not perfect.
But I can tell you from being in many other countries around the world and seeing their justice systems, it's still the best one out there.
Yes, it is, and it's really difficult for victims to sit through a trial like that too.
Oh, yeah, that's the other
Yeah,
thing.
really painful.
Sometimes the decision and one option given to victims in non-murder cases and families in murder cases is, do you want to go through the emotional turmoil, incredible difficulty?
Viewing the evidence, the photographs of their loved one murdered is just painful, and the whole world gets to see that.
Oh, it's crazy.
So-
I defended a capital murder case early in my career as a defense attorney, and there was a autopsy picture of the young woman who was killed. And I have to tell you, I can close my eyes and still see it.
Of course.
I'm still horrified by it. These cases can have a traumatic effect on everybody,
Yeah,
even the defense attorney.
you're right. So all these things are considered by the prosecutor, including the victim's input, before they decide whether they're pursuing the death penalty
Right.
or life in prison in this case. So
Talking about sentencing,
Oh, yeah.
I also want to talk about the case that seems to be the most in the news right now, which is the Diddy case.
Yep.
And I know you were involved in the case, but we're not going to talk about your involvement because that's over with.
Well, it's
And-
not totally over with because my client might have to testify at sentencing, which is October 3rd. So, yeah, I can't really talk
We
to
can't talk about the case, but
Right.
we can talk about what might happen
Yes.
in the sentencing. And the interesting thing that, when you read in the news and people, our audience, they hear that, well, a maximum sentence of facing 20 years.
Right.
Well, that's the statutory maximum. It's very rare that when you have a statutory maximum, unless in a murder case or very, very serious crime, that defendants ever get the statutory maximum. In federal court, what happens is there's a federal sentencing guidelines system. It's a point system. And it's a book that's, I think the book teaching you how to build an atomic bomb
It's shorter.
is shorter.
Right.
It's thinner than the book for the sentencing
And there's some
guidelines.
lawyers practicing 100 years that still don't understand the
it's crazy.
sentencing guidelines.
And the sentencing
Very
guidelines
complicated.
used to be mandatory to judges.
Right.
They had to follow the guidelines. Now it's permissive. They don't have to. But they generally use it as a guidepost. And in the Diddy case, what I've read, again, this is what I've read, I don't know for a fact, but it's probably accurate, is that the prosecution is asking for a sentence of 57 to, I think
it's 51 to 63.
51 to 63 months.
So, yeah,
And the defense is
21 to 27
and what
months.
those numbers are the guideline range. And the way that they come to different numbers is that the prosecution is contending that certain provisions in the guidelines apply, and the defense is saying they don't apply. And that's why we have a sentence of much lesser amount believed to be the appropriate sentence by the defense. And the way it works is The probation report will calculate the guidelines, and then both parties will have the right at the time of sentencing, or they'll put it in written form, in memos before sentencing, but it will be determined at sentencing which are the appropriate guidelines.
Right.
And once that's decided, it doesn't mean the judge is going to follow those guidelines. The judge can go below or can even go above. And the judge will listen to the recommendations of both sides. But in this case, the interesting aspect of this case, and it happens a lot in cases, is Diddy was acquitted of the most serious charges, and he was only convicted of 2 charges under what we call the Mann Act,
Right.
which is the interstate transportation for purposes of sex prostitution.
Right. So just in case any of our listeners have been on vacation for the last 3 years, or actually about a year and a half,
Or in a coma.
in a coma, and living under a rock. There were 5 counts. 3 of them actually were life felonies. If he was convicted, he could get up to life in prison. He was found not guilty of those 3, and there was, there were 2 sex crimes and then a racketeering. The 2 counts of the 5, he was found guilty of 2. Those were transportation for purposes of prostitution. Those carry each a maximum of 10 years. And people may have heard these terms, but we'll define it for them. You get punished with more than one count, either on consecutive punishment or concurrent. If a judge issues a consecutive punishment, it means that you have to finish one. Let's say he gives them 5 years on the first count, then he starts. They're stacked. Concurrent, do first sentence of 5 years, then you start the second
That's
5 years.
consecutive.
Very often they'll do concurrent, where if you get 5 years on both counts,
They run together.
They run together. So that's what he's facing now, are those 2 counts. And you kind of talked about this score sheet. You referred to this pre-sentence investigation, the probation report. Now, what I read, again, the news isn't always accurate, but I read that the defense is trying to get the sentencing sooner, and that there's some talk from the judge or the prosecutor saying, we'll agree to go sooner than October 3rd if you waive the pre-sentence investigation, which is the report probation does, where they do a major investigation of the defendant and his family and his background and so forth, and then they come up with their own recommendation for sentencing. So, again, we're not there in the courtroom representing the government or representing Diddy.
That's an interesting tactical decision. I mean, in this case, the judge has pretty much heard everything.
Everything.
And so what's the report going to give? It'll give the background of Diddy, but it'll also, the probation officer who technically works for the court will be making his or her own determination, obviously reviewed by their office and their supervisors, as to what the appropriate guidelines should be. And then that means it's going to be an uphill battle for one side or the other to contest that. So I don't know. I mean, I don't know enough about the case, and I'm certainly not going to put myself in the shoes of the defense attorney, who, by the way, did a masterful job in this case. A great job in this case, and kudos to them. But here's the interesting issue. The interesting issue in this case is the judge has heard a lot. And the judge, even though the law now is that once you're acquitted of charges, that conduct cannot be considered in determining the guidelines.
Right.
It can only be the conduct that's convicted.
That's why it was good that you actually kind of defined and laid out what these guidelines are. You get points. It's a point system.
Right.
If you're convicted of those 3 charges, you get points for those, and those go toward a longer sentence. In this situation, under the law, he can get 0 points for those because he was acquitted of those 3 counts.
Right. They don't count in the determination of what they call the base offense level and then some of the other adjustments. But nothing prevents the judge from considering whatever conduct the judge heard, whether the jury found it not credible or not proof beyond a reasonable doubt. Nothing prevents the judge from considering that in determining the sentence, because the judge, as long as the judge's sentence is within the legal range, that is below the maximum and within the legal range, there's not a lot that can be done about that. So,
I mean, what you're saying
you can
is
appeal the sentence,
right.
But good luck.
Yeah, I mean, what you're saying is if the prosecutor is asking for 51 to 63 months, defense is asking 21 to 27 months, and let's say the judge decides, and you can get up to 10 years per count. Let's say the judge says, I'm giving you 10 years, total, 5 years on each to run consecutive, whatever. The judge has the right to do that.
Yeah.
And they could do that based on hearing, what type of person he is through all this other evidence. And the judge might say, well, you didn't commit a crime beyond a reasonable doubt, but there was evidence that you behaved in certain ways, which I think
The judge has to be careful, because if the judge starts talking about it in a way that sounds like the acquitted conduct was utilized for the purpose of fashioning the sentence, it sounds like it's probably unlikely. Again, we're not involved in the case, but it's based on experience. It's probably unlikely that the judge will exceed what the prosecution recommends.
very rare they do that.
It's very rare, but I had an incident.
It does happen.
I had it in the Rothstein case.
That's right.
In the Rothstein case, the government recommended 40 years. This was the multi-billion-dollar Ponzi scheme.
By a lawyer, by the
asked
way.
by
He
a
was a
lawyer.
lawyer.
In addition, he forged judges' signatures on orders. There's a lot of other stuff he did. And we'll talk about that case in detail in one of the episodes. But I requested 20 years. And we had an agreement, a cooperation agreement, in addition, so we knew whatever it was going to be, it would be reduced later on if everything
That was the
worked
plan.
out. That was
Right.
the plan.
That was-
Didn't work out quite
No.
that way, but that's a whole nother story, whole nother episode. The judge gave him 50 years.
Yeah, they do that sometimes. And that could happen here. A lot of people said to me, Guy, how did he deny bond and bail? So after a verdict, you can then raise the issue of, can our client be released? And the defense did that. I said, look, he's been held no bond on these 5 counts. He was found not guilty on the 3 really most serious counts. We would like you to release him now. They offered up $1 million. We'll surrender his passport. And the judge denied it.
Now, usually in that situation, the determination is whether the person is a danger to the community or a flight risk.
Well,
I don't know if he was. I don't remember reading the order. I just saw the news article. I don't know if the judge determined
he
it was a
did.
flight risk.
The judge, well, not the flight risk. He said
Danger.
Yeah, the judges, I have a quote from him. Throughout this trial, we've seen numerous times where the defendant shows a propensity to commit violence amongst people in the community. And that was his legal basis for denying bail at this stage. I've often, in these cases, you'll think, well, the judge is afraid they're a flight risk. But if someone's gonna get a short sentence like this, well, certainly even a day is too long of a sentence for me. But and if let's say he gives them 3 years, 2 years, that's not really
It
gonna
would be insane
to think that someone's
to
a flight
become a
risk.
fugitive.
Right,
I've
for
had
that.
a number of clients over the years become fugitives, and I told one story earlier about the pilot for Jamaica. But what I've learned from those experiences is, number one, it's very expensive to live as a fugitive.
Yes, it is.
Okay? And you're very likely to be extorted by either the local government.
As soon as they realize you're on the lam,
Because
absolutely.
the reality is, not all, but most of the places that don't have extradition treaties with the United States are, for lack of a better word, shitholes.
Yeah.
The places you don't want to
You
be.
don't want to be there.
And the other thing is, so you're either extorted by the local government. I had a client, he was building parks and playgrounds. He was keeping them happy until all of a sudden he didn't, and then they threw him out. And we've heard situations like Vesco and other fugitives in the past who ultimately overstayed their welcome and were thrown out and returned. The other thing is, you've also got private individuals who find out who you are, who can extort you.
Right.
And the other problem is, you've got this potential of being caught or going to the wrong country that has a treaty and being found out, or through immigration, whatever, and wind up being extradited to the United States. So you're living with that sort of Damocles over your head. It's crazy. And so it doesn't make sense.
25 years ago, maybe not so much, but in this day and age with the communication and the ability to
Also,
track
how is Diddy
people.
going to hide?
Right. He's not, everyone in the world knows what he looks like and who he is.
I can't imagine he
The other thing I've heard judges say is, and I've had this conversation with clients is, when they've unfortunately been found guilty is, if sentencing is in, say, 45 days or 90 days, do you really want to, you've been in for a year and a half already, do you really want to go out of the jail for like 30 to 45 days and then you're going to get sentenced to some prison time? So really, why don't you just stay in?
Well, that's a good point.
Continue to get credit for the time that you're going to get
Not only
punished.
that, it's though you get out, you taste that freedom again.
Yeah.
It makes it twice as hard to go back
in. Then it's a horrible emotional roller coaster for people. So I always encourage them, you're better off just stay put and get credit toward the ultimate sentence. You'll be out that much sooner. So, but, it could be a red flag or I'm sorry, like a foreshadow, a prediction. This judge denying bond could be a prediction that he's going to be harsh at sentencing. We'll find out October 3rd, maybe sooner. If the defense gets their way and gets it moved up in time. But we'll find out. It'll be a very interesting day. I know there'll be millions of people watching that sentencing. I think a lot of people out in Hollywood and the music industry and so forth, and they've been following this case closely because P. Diddy's a very, very powerful person. And, the government taking him down would send a loud message to a lot of people out there about how, they need to conduct their business and so forth. So it's everyone's watching this verdict and the sentencing coming in a couple months.
Well, fascinating.
Yeah.
And I think we're going to wrap it up. I need some water.
All right, there's some water for you. It just magically appeared from Ben the engineer. Thank you, Ben. But yeah, so and then of course there was some news this week in the Jeff Epstein case, which I can't say too much because even though he's deceased, how he died is a whole nother story. But even though he's deceased, the attorney-client privilege continues for the rest of my life. I cannot repeat things even though he's deceased. But there was an interesting news this week that you can share with, if you want, about whether the...
Well, the Justice Department released a memo, and in it stated basically two things. Number one, it concluded that there's no evidence that he died by other than suicide.
Which people who listened to our first podcast, I gave 7 reasons why I know or certainly believe that he was murdered. I gave 7 reasons in that episode, but they're now saying that he died by suicide.
Well, they're saying there's no evidence
that
he died by other than suicide.
Right.
The second portion of that memo is they say there is no client list. Sure. Now, what's interesting is, and where the media and other people have jumped on this, is that Pam Bondi, the Attorney General, had previously said in an interview on one of the news shows that when asked about the list, she said, it's sitting on my desk right now. I have to review it. Now the administration is explaining those comments by saying she meant the file, not the list. Now, a lot of people find that hard to believe. I don't know. But we all know that there were a lot of powerful people who were concerned about the exposure of even being involved with him, whether they were involved in the activity that was subject to the criminal case or they simply associated with him. I suspect, I don't know, and I'm going to ask you flat out, not based on privileged communication, but I suspect there's got to be a list out there, or at least a list of people who visited that island.
And there is, if people dig deep enough into the public record, they'll find this out. I think we need to understand the definition that they're using, that Pam Bondi, Attorney General Pam Bondi is using for lists or so forth. But there were flight manifests. for his private plane. They had the pilot's names and all the passengers' names, and going from point A to point B. They have lists of who was on the island. Now, are these, how are you defining client? Are they people that he had sexual relations with? Are they?
Or you mean were involved in the sexual activity with the young women?
Correct. How is it being defined? But there were a lot of documentation in that case. I was, as I mentioned in our first episode, I was there in the home when it was searched. Lots and lots of files were taken out of the home. So I don't really know how they're defining the list, but there was a paper trail for, who was at the island, who was in his home, who was on his airplane, and, phone numbers and so forth. So there's lists out there, and that's if he had ever gone to trial, I'm sure a lot of those people would have been called as witnesses and so forth. But it's out there somewhere.
Well, this is a controversy that will never end.
That's right.
And people will have their opinions. And, a lot of people don't trust what the government's saying.
Some people think Jeff Epstein's still alive. Right. I've literally had at least 24 people over the years say to me.
Elvis too,
Yeah, Elvis is still alive, so I was at Graceland recently, so I think he was there, but I saw a bunch of...
He'd be an old man by now.
I saw a bunch of Elvises.
But in any event, given the ongoing controversy, there will be people who will continue to believe and people who don't trust the government. And it remains to be seen what the truth is. But we know one thing. He's dead.
He is dead.
Okay.
That I do know.
And that's
I got the
it.
call that morning. Yeah.
That's it.
And, this was a fun episode. It was outside of our norm.
Right.
We will occasionally talk about these cases that are in the media because we know people want to hear our perspective on them, again, on the process, not the facts. And since we aren't working those particular cases, and we'll have some guests occasionally. We'll talk about some movies that are about criminal topics.
Yeah. The whole idea is to both amuse and educate.
I like that. Amuse and educate.
Amuse and educate.
That's right.
And so, ladies and gentlemen, until our next episode, you're
free to go. Down Low Investigations is a sponsor of You're Free to Go. Behind every great criminal defense attorney is a great private investigator. That's why Marc and I use Down Low to investigate cases all over the country. Down Low can help you too, whether you're running a background check on an employee or running a background check on a blind date, or let's say you need someone followed or some other type of investigative work conducted. Down Low is the way to go. Call Download Investigations at 561-843-1806. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fronstin and Marc Nurik and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.